Dr. B. Suganya from the Department of Commerce CA. Today we are going to see about the LLP, that is Limited Liability Partnership. And the Limited Liability Partnership Act 2008 is applied to the whole of India and it is commenced in the year 2009 7th January. But while talking about the act, we will tell about that is LLP 2008 because the Parliament passed the bill in 2008 but in 2009 the President signed. So we have to use the act as 2008 only. The LLP Act take the advantages of both the partnership and the company. In the partnership, the advantages limited, flexible and the disadvantages unlimited liability. But in companies, the advantages limited liability but the disadvantages not flexible. By combining both the advantages from the partnership and the company, the LLP Act was formed. So, it is a hybrid of both the partnership and the company. In LLP, we are having the two main advantages. One is flexible and another one is limited liability. The LLP has totally 81 sections and 4 schedules. There are 4 schedules in LLP. The first schedule gives detail about the mutual duties and rights of the partner. The second schedule deals with the conversion of the firm into LLP and the third schedule deals with the conversion of a private company into LLP and the fourth schedule deals with the conversion of the unlisted public company into LLP. That is, here we have seen in the fourth schedule as unlisted public company. That is, it cannot raise its funds by trading its shares in the stock exchange in India or abroad, but it can raise its own fund privately from the public. So, it is called as a unlisted public company. The next we are going to see about the characteristics of LLP. The first one is body corporate because it is registered under the LLP Act 2008. So, it has a separate legal entity. As individuals, we can do all the functions. The second one is limited liability. Already we have seen that the main advantage of LLP is limited liability because the partners are liable only up to their contribution to the company, to their business. So, if any losses occur in the company, they cover only up to their contribution. So, the partners' own property does not affect the company's loss. The third one is perpetual succession. LLP continues to exist even if the partners leave or retirement or dissolution happens, the company will exist but if any changes occurs. And the next one is flexibility. Already we have seen that the advantage of flexibility is taken from the Partnership Act. That is, flexibility means the partners can frame their own duties and responsibilities of the partners. And the next one is mutual agency. No partner can bind another partner and LLP itself is liable, not the personal assets of the partners. The example is if the partners invest some capital, that is for example 10 lakh to their business, means if the loss occurs up to 5 lakh means they are responsible only to that amount, but their personal property are safe. And the next one is LLP agreement. Flexibility to devise the agreement as per their choice. They can frame their own duties and responsibilities. And the next one is artificial legal person. It is as individuals, it is a separate legal entity. So, it can be dissolved only by law. And the next one is common seal. It has its own stamp or signature in LLP. that is used to authenticate the documents used in the business. And the next one, limited liability, protection of personal assets and risk limited to investment. If an LLP has a debt of rupees 10 lakh and a partner A contributed rupees 3 lakh to their business, means he will lose only 3 lakh but his personal assets are safe. So up to 3 lakh only he is liable. That is called as the limited liability. And the next one is designated partners. In LLP, there must be at least 2 designated partners, and among the 2, one must be the resident of India. That is, at least in that particular financial year, he should reside in India not less than 120 days. So, among the 2 partners, one partner should be from the resident of India. And the next one is management of business. Personally responsible if the LLP fails to comply with the statutory requirements. The next one is minimum and maximum number of partners. In LLP, there must be minimum 2 members, and for maximum there is no limit. And the next one is business for profit only. In LLP, the partners are joined together to earn profit from the business. They cannot use LLP Act 2008 for charitable or trust or for non-economic purpose. So, their only motive in LLP among the partners is to earn profit. And the next one is conversion into LLP. A firm, private company or unlisted company or public company can convert into LLP in accordance with the LLP Act 2008. And foreign LLP. A LLP formed, incorporated or registered outside India which established a place of business within India. Foreign LLP can become an Indian LLP. But in LLP, if the firm is converted into an LLP, means there are 2 conditions for the financial year. If they are registered before, if the conversion is done before September month, means they can, their financial year is March, and the next one is if they are converted after September, that is, for example, they have converted into LLP in October 2025, means their financial year will be extended to more than 1 year. That is, their financial year will be March 2027. If they are converted before September, means for example, if the conversion is done before September, that is on the month of June 2025, means their financial year will be March 2026. So, there must be minimum 18 months for their financial year for file their documents. So, these are the characteristics of LLP. LLP is formed among the partners to earn profit only, and not for charitable or trust and non-economic purposes. So, these are the characteristics of LLP. Thank you.